I've got an interesting question for you today. In a medical malpractice case, when you are questioned during your pretrial question and answer session, if you fail to answer a particular question by the defense lawyer, can the defense lawyer force you and compel you to answer his question? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the short answer is yes, he can. The defense lawyer during this pretrial question and answer session can force you and compel you to answer his questions, except, there are only two exceptions, except if the lawyer is trying to ask you about things that you and your attorney spoke about at any time. He can't do that. You want to know why? Because those conversations between you and your attorney are confidential. They are privileged. So your attorney will likely yell out, "Objection! That's privileged! Ask another question, counselor." And all that means is that any conversations you have had with your lawyer is private and confidential, and the defense lawyer cannot learn the details of that conversation. He can learn about the fact that you spoke. Certainly there's no problem with you speaking to your attorney, and it's expected. The other exception where the attorney cannot compel you or force you to answer a question is where he asks you a question that is so off the wall, bizarre, and outrageous. We call that a palpably improper question. Now, here's an example. Let's say you sued your doctor for improper medical care and you believe he caused you significant harm and injury. The defense attorney now, during your deposition, asks you a question and says, "Hey, Mr. Jones, how often do you beat your wife each night?" And you're looking at him like he's an alien, like, what? What are you talking about? What are you talking about, beat my wife each night? That is a palpably improper question. It's so off the wall, it's so bizarre. It's got nothing to do with the claims that you are bringing. It's got nothing to do with the damages you are claiming. It's got nothing to do with the defenses that have been raised in this case. And he has no proof whatsoever that any such nonsense ever occurred. So in that instance, you would be fully within your rights to turn around and say, "Counselor, I'm sorry, but that's a totally inappropriate question. And by the way, you don't actually have to say that. Your attorney will be the one objecting, saying, 'Counselor, I object. That question is palpably improper. Do not answer that question. Move on to the next thing.'" So let's say as part of your claim, you are alleging that you can no longer have sexual or intimate relations with your spouse. And now the defense lawyer starts to ask you questions about your sexual activities. And you feel very uncomfortable answering those questions. So you tell him, "Listen, I'm not answering questions about my sexual activities with my spouse." Can the defense lawyer compel you and force you to answer those questions? The answer is he can. You want to know why? Because if you continue to maintain that part of the claim, that you believe that your sexual activities and your intimacy with your spouse has been severely affected because of his client's carelessness, the doctor's carelessness, then guess what? The defense attorney has an absolute right to ask you questions about that part of the claim. "Hey, Mr. Jones, can you tell me what your sex life was like before this doctor you claim screwed up?" And now you have to go ahead and answer those questions. And if you choose not to answer those questions, your attorney will likely pull you out of the room and say, "Listen, if you choose not to answer those questions, you will not be able to prove that you are more likely right than wrong, that your sexual activities are affected or were affected because of this doctor's carelessness." And that will no longer be part of your case. So if you are continuing to maintain that particular claim, then yes, the defense lawyer has an absolute right to ask you questions about that. And if you actively choose not to answer those questions, your lawyer is going to remind you, "Listen, then you won't be able to bring that part of the claim as your damages." You have to make that choice. Do you want to bring a claim for the loss of intimacy with your spouse and the loss of sexual activity, which is certainly a valid part of your case, assuming that's true? In that instance, if you say yes, now you have to answer the defense lawyer's questions. So that's what I mean when I say, hey, the defense lawyer can compel you to answer those questions, because if you refuse to answer, then he's now at a significant disadvantage and can no longer create a defense or understand what your claim is if you actively choose not to answer a particular question. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I do recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.